Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 148. You can probably tell from the surroundings, the sound here, that we're actually in new surroundings. We've recently moved floors and the recording studio, ho-ho, has moved with it. So I hope the sound levels and sound quality continues. Anyway, I think I missed a week between podcasts. We've had a bit of a surge on the work front, which of course as head of the team is immensely satisfying, but it does leave less time for me to do things like the podcast, unfortunately. I would say, as usual, we've got 3 cases to go through this week, but that wouldn't be true. Instead, I've got 2 cases. We've got one in the Court of Appeal on the Agency Workers Regulations 2010, and a case decided in the AT to do with automatic unfair dismissal claims. And then I thought I'd talk a little bit about the proposed non-disclosure agreement reforms and why I think there's very little in them that should be of concern to responsible employers and their advisors. Please don't forget podcasts available via iTunes. It's on the Mayor Brown website, YouTube, Twitter feed, Nicholas Robertson at Nicholas ROBER11, which is where we post out links to all the cases discussed, of course. 2 other things. I'm going to have a podcast recommendation for listeners at the far end of this, and a plug for a special guest podcast I'm going to do with the barrister Chris Milsom in connection with the case that he was involved in, which I think is a really interesting case. So keep your ears peeled for that. So first case, London Underground Limited and Amisar and others. Now, this is a Court of Appeal decision dealing with the Agency Workers Regulations 2010. It's the first case to go to the Court of Appeal on the apportionment of responsibility between an agency and the hirer, where there's been a breach of regulations affecting the people whose labour is being made available. As such, I think it's a really important case. It's also very well written, very clearly written, deals with some quite difficult issues. The claimants were employees who'd worked for a company called trainpeople.co.uk Limited, referred to as TP throughout the judgment, so I'll do the same. TP provided the claimant services to London Underground Limited for a number of their stations in northwest London. The arrangement was originally entered into with another company, but when London Underground took over those stations in 2007, they inherited TP, and then they arranged a new contract with them, which expired in January 2013. The Agency Workers Regulations 2010 came into force on 1 October 2011. They're not particularly easy to follow, but broadly speaking, Regulation 5 gives agency workers the right to the same terms of pay, duration of working time, night work, rest periods, rest breaks and annual leave as individuals would have had if they were directly employed by the hirer, i.e. as if these claimants were working directly for London Underground. Originally, TP took the view that the Swedish derogation meant they did not have to comply with Regulation 5. However, towards the end of 2011, i.e. 2 to 3 months after the regulations came into force, London Underground started to raise concerns with TP as to whether this was entirely correct. London Underground then did an investigation and decided the rates paid by TP to the claimants should be increased to comply with the regulations. However, sorting this out took time, because TP could not pay the right rates until London Underground had provided the applicable rates for comparators. Therefore, it wasn't until August 2012 that London Underground provided the correct figures and correct payments. Payments for arrears were then made by London Underground to TP from mid-October 2012 onwards, so that by May 2013, both the arrears payments and updated payments had been provided to TP to pay to the claimants. However, TP, apparently dishonestly, failed to pass on the arrears payments despite being chased many times by London Underground to do so. TP then went into insolvent liquidation. So, the issue in a nutshell was that you have a group of claimants who have not been paid money potentially that is owed to them, and the obvious bad guy, TP, is no longer around to take responsibility. London Underground had paid the bad guy all of the money that was due to the claimants. Were London Underground still liable under the regulations for the non-payment of the monies to these individuals by TP? The judge found that the Agency Worker Regulations 2010 had envisaged that it may be necessary to apportion responsibility between the hirer, London Underground, and the agency, TP, where there had been a breach of rights. Regulation 14, for example, provides that the agency and the hirer are liable to the extent they are responsible for the breach when it relates to a failure to make due payment. Regulation 18 says that where compensation is awarded, the compensation shall be such as the tribunal considers is just and equitable in all the circumstances, and furthermore, in paragraph 18.9, the amount of compensation payable by each respondent shall be such as may be found by the tribunal to be just and equitable, having regard to the extent of the respondent's responsibility for the infringement to which the complainant relates. So in other words, there are two set provisions which talk about parties being responsible to the extent they are to blame for the breach, and there's a just and equitable bit in there as well. Before the Employment Tribunal, the judge decided that the original underpayments caused by TP asserting that it benefited from the Swedish derogation were not London Underground's fault. Therefore, at that point, TP was solely liable for the original underpayments. However, London Underground had, the judge decided, been very slow in providing information to TP that it needed when London Underground decided that it wanted to ensure that the claimants were paid at the correct rates. On that basis, the judge said he apportioned liability 50% to London Underground and 50% to TP. However, when it came to the remedy, the judge pointed out that he had a further discretion to do what was just and equitable, and bearing in mind that London Underground had put TP fully in funds to pay the claimants, and it was owing to TP's insolvency that the claimants had lost their right, and they had, he said, the claimants delayed enforcing their claims against TP, it wasn't fair and appropriate to require London Underground to pay more money to the claimants. The matter went up to the AT and then on to the Court of Appeal. The Court of Appeal were very clear, and although they paid tribute to the Employment Tribunal judge's original reasoning, they disagreed with it strongly. The Court of Appeal pointed out there had clearly been underpayments from December 2011 onwards until 15th October 2012 when the correct payments were being made, but the arrears were not being paid. Although the regulations talk about awarding compensation for the breach, clearly here the compensation was to be paid on a pound-for-pound basis for the underpayments. Bearing in mind the judge had found that London Underground were 50% to blame for the breach, the question was whether that was the beginning or the end of matters, or did a further discretion exist to take account of the fact that London Underground had put TP into funds. Even if that discretion did exist, was it relevant that London Underground had put TP into funds? Court of Appeal accepted it was in principle possible that the reference to what is just and equitable could permit a tribunal to require a respondent to pay a lesser share of the compensation than it was responsible for in terms of having created the original breach. But such a case would be exceptional. Here, however, the Court of Appeal did not accept that it was just and equitable to deprive the claimants of the compensation that was due to them, because of course that would be the impact. The claimants were completely innocent in all of this. Any alleged delay in enforcing their rights did not have the effect of depriving them of the fundamental right to receive the payments that were due to them. On that basis, the Court of Appeal said that compensation should be set at 50% of the total sum due, i.e., in line with the tribunal judges' findings for the responsibility. There was no need, the Court of Appeal said, for this matter to be remitted back to the tribunal. Now, my reason for going through this case is that I cannot imagine it's going to be the only time when hirers of agency workers will make arrangements with agencies that subsequently go into insolvent liquidation. This case means that companies do need to be aware that if the agency goes into liquidation owing the individuals money, under the Agency Workers Regulations 2010, those claims may wholly or partly come through to the customer. After all, as the Court of Appeal pointed out, it was London Underground who chose to deal with TP, and so should take the risk here of having to pay twice over, partly because of TP's insolvency. So, that's the case of London Underground Limited and Amissa and others, and why companies need to choose their agencies carefully if they're providing agency workers to them. Secondly, the quite wonderfully named Mr. Spaceman and ISS Mediclean Limited. This concerns an appeal by the appellant, Mr. Spaceman indeed, against a tribunal decision striking out his claim. Mr. Spaceman had been employed between October 2015 and June 2017 when he was dismissed after allegations of sexual harassment. During the disciplinary hearing, he asserted that the decision to dismiss him had already been taken, because one of his work colleagues declined to help him in the hearing and told him he was going to be dismissed in any event, and that the disciplinary officer had been told to dismiss him. Well, Mr. Spaceman was dismissed and he brought a claim on a number of bases. Obviously, since he didn't have 2 years continuous service, he couldn't bring an ordinary claim of unfair dismissal. However, he did bring a claim under Section 104 of the Employment Rights Act 1996, which is dismissal following the assertion of a statutory right. Since Section 104 is often overlooked in favour of the whistleblowing provisions in Section 103, it's probably worth spending a couple of minutes just walking through Section 104. Section 104 provides that an employee is unfairly dismissed and doesn't need any qualifying period of service if they have brought relevant proceedings against the employer or have alleged that the employer has infringed a right of theirs, which is a relevant statutory right. Relevant statutory rights include any right given to the individual under the Employment Rights Act 1996, where the remedy for that right is to go to an employment tribunal. So, in essence, it's a form of anti-victimisation. If you assert a statutory right that has been broken and the response is that the employer sacks you, then you have effectively a victimisation type claim. Section 104.2 says it's immaterial whether or not the employee actually has a statutory right or whether or not that right has been infringed, provided that both the claim to the right and the assertion that it's been infringed are made in good faith. So here, the employee was saying that the dismissal process was a sham because the decision to dismiss him had already been taken. He therefore asserted he was being dismissed for asserting a statutory right, i.e. the right not to be unfairly dismissed. Well, the Employment Tribunal struck out his claim because the assertion was that the relevant statutory right had been broken, not that a statutory right was going to be broken. The EAT judge allowed the appeal to go through to a full hearing. Although, I should explain, there were particular problems with the claimant's assertion that he was dismissed for asserting a statutory right, not to be unfairly dismissed. But the problem was, in the EAT's view, whatever the merits of that in relation to a dismissal for asserting the right not to be unfairly dismissed, other statutory rights were also protected by Section 104. In those circumstances, the EAT judge, considering leave to appeal, acknowledged that the tribunal's interpretation that the right had to be an assertion that the right had been broken, not that the right was going to be broken. That would mean that the ambit of Section 104 was rather narrower than people had thought. Well, at the full appeal, the EAT decided the Employment Tribunal had been totally right to strike out the claim. Section 104 had to be given its natural meaning. Section 104b says that if the individual is to be treated as unfairly dismissed, if the employee has alleged the employer had infringed a right of his, which is a relevant statutory right. The use of the past tense, had infringed, according to the EAT, was deliberate. It would have been possible to protect the employee against future threats of breach to a statutory right. That's not what the legislation says. Additionally, and of course, both the Employment Tribunal and the EAT indicated there was a logical inconsistency in the appellant's arguments. If the appellant's case was that the employer had already decided to dismiss him, then it was difficult to see how that dismissal could have been decided because the employee had asserted at the disciplinary hearing he had a right not to be unfairly dismissed. It was a circular argument. Well, on that basis, the EAT said the employee had to be asserting that a statutory right had been breached, not that a statutory right was going to be breached at some point in the future. That avoided the circular argument because it was clear that the appellant, at the point in the disciplinary hearing when he had made the statement that he was definitely going to be dismissed, had not actually been dismissed. He was attending a disciplinary hearing to try and avoid being dismissed, although he said it was a sham. The caveat that the EAT did offer was that given that a number of the claims that are covered by Section 104, I should say rights perhaps, the statutory rights that are covered by Section 104, well, they derive from European law. It's possible that European law might require a different process of statutory interpretation. I thought it was useful to go through this case, although it relates to a fairly narrow point. First, it's relatively easy to overlook Section 104 and focus on the whistleblowing provisions in Section 103A. The dismissal for asserting a statutory right does not require the employee to establish that there is a public interest element in the claim. It also does not require the employee to be explicit about the statutory right being infringed. Section 104 states the employee does not need to specify the right, merely make it, quote, reasonably clear to the employer what the right claimed to be infringed was, unquote. So I think Section 104 is something to keep in mind if you have an employee who is making assertions that the employer has acted in breach of obligations owed to him or her. But it does need to be an assertion that the right has been broken. So that's the case of Mr. Spaceman and ISS Mediclean Limited. Now, I wanted to say just a few words on the proposed reform of non-disclosure agreements. The government's recently brought a consultation process in connection with the proposed increased regulation of non-disclosure agreements. And I want to say a few words about those, given they're very much in the press at the moment. Equally, having looked through the proposals, I hope you'll agree with me at the far end of this section, there's really nothing here that should cause concern to reasonable employers and their advisors, or indeed reasonable employees and their advisors. Government proposals recognise quite rightly that non-disclosure agreements, or more likely non-disclosure clauses, form part of contracts of employment in the form of confidentiality clauses, but obviously also most obviously form part of most settlement agreements. The government recognises these clauses have a place to play in enabling an employer to protect its confidential information, and in the context of settlement, enabling the parties to move forward from an agreed settlement without publicly relitigating the subject of the dispute. Interestingly, the government's proposals would treat the two forms of NDA, the one contained in the contract of employment and the one contained in the settlement agreement, well, it would treat them differently. The proposals suggest that NDAs would have to be explicit about the limitations in their ambit. That applies to both types. For example, the government suggests it should be made clear that disclosure to the police of any wrongdoing should always be an unfettered right. It's not suggested this should be limited to circumstances in which a whistleblowing disclosure would be permitted. The government invites considerations as to what exclusions should be included, and obviously I anticipate that disclosure to an appropriate regulator of wrongdoing is likely to be added to the list. It's difficult to see why an NDA clause should be able to limit disclosure to a regulator when it would be invalid to limit disclosure to the police. It provides that NDAs and settlement agreements would only be valid and enforceable if they'd been entered into after the individual had received independent legal advice. Well, since by definition, by far and away most settlement agreements are entered into after independent legal advice has been taken, this is hardly a radical change. It will, however, be necessary for the individual to be advised about the NDA clause itself by the independent advisor and the limitations applicable to the NDA clause. The government's proposals, if the NDA clause in a settlement agreement is not compliant, or presumably if the individual has not had independent legal advice, is that the clause itself is entirely void. In other words, if the employer overreaches and tries to protect something by an NDA clause that it should not be protecting or prohibiting, it loses all NDA protection. I think the analogy is perhaps it's a bit like a restrictive covenant. If the employer overreaches itself, it can lose the full protection of the restrictive covenant. But I don't think that analogy really holds good. First, experience indicates that in many cases the employer has a desire to maintain confidentiality as well. What would this remedy do about a situation where the employer had been guilty of some wrongdoing, but the employee had also been guilty of wrongdoing? The employer could easily say to the employee, "Fine, go ahead, ignore the NDA clause in the settlement agreement. I too will then be free to broadcast what I know about you." So, whilst it feels like the obvious way of enforcing this sort of clause, and it may indeed be the best way, I'm not sure it'll necessarily work in all cases. In relation to NDA clauses and contracts of employment, the government is not proposing that these should be signed up after independent legal advice has been obtained. Employers, of course, want to have confidentiality clauses to protect their confidential information. And equally, confidentiality clauses may inhibit an employee from disclosing wrongdoing to third parties if it is felt that the information disclosed might be confidential. Well, here, therefore, the government is proposing to adopt a remedy similar to the remedy for breach of Section 1 of the Employment Rights Act 1996. That's the duty, if you remember, to provide a statement of terms and conditions within a specified period of joining employment. There, if the employee brings another tribunal claim, then the employee may piggyback a claim for breach of Section 1 on that claim, and the tribunal must award 2 weeks' pay for breach of Section 1 and can award 4 weeks' pay for the failure to provide the necessary terms and conditions. The government's proposing something very similar here. I think this is a very weak solution. First of all, the employee's got to know about this right, and remember the employee won't be getting independent legal advice as a precondition of entering the contract of employment. Secondly, the employee has to have another statutory right which is broken, which the employee wants to bring a claim for. And thirdly, and as with NDAs and the settlement agreements, the employee has got to want to publicise whatever the wrongdoing is. So I think it's pretty unlikely that unduly restrictive NDA clauses and contracts of employment will be challenged if these proposals hold good. One option, I suppose, but I'm giving this some thought, would be to provide that the employer is not entitled to enforce a duty of confidentiality in an NDA clause if it is not drafted appropriately. The waiver for this NDA clause would, however, not cover proprietary confidential information belonging to the employer, but might permit disclosure of allegations of wrongdoing by the employee. It's an idea. I'm not sure it is necessarily a lot better, but it is a thought. The government is not proceeding with two ideas which were floated by the Women and Equalities Select Committee, which had suggested in certain circumstances proposing an invalid NDA could be a criminal offence. Secondly, the committee had suggested that there should be a standard clause or formal wording that the parties would know they could rely on without being in breach of the law. The government has decided not to be so prescriptive, but my personal opinion is that some assistance from ACAS in this area is likely to be helpful. Nonetheless, I think that for most employers, if these proposals become law, then it would necessitate a redraft of contracts of employment and settlement agreement precedents for a couple of clauses. There may be some head-scratching about what to do with existing employees, where the confidentiality clause in their contracts does not have the now required express exclusions. I can see some sort of side letter being issued en masse to staff. But having taken these two steps, I don't think the landscape is likely to change significantly as a result of these provisions. I'd be very interested if anyone disagrees. Do let me know. Well, that's the government's proposed review of non-disclosure agreements, and we'll see with everything else that's going on these days quite how the government gets on with that. So, thank you very much for listening to Podcast 148. Got a guest episode coming up very shortly with Chris Milsom from Cloisters, talking about a case he was involved with, which has a general and considerable significance, I think, for employers and employees. So do please listen out for that. I think it'll go out in the next week or so. Oh, I said I'd mention a podcast. A friend of mine, Peter, has been banging on for a while about Revisionist History by Malcolm Gladwell, and I finally got round to listening to a few episodes. It's really good. For anyone listening to this podcast, if you want to weigh into the Malcolm Gladwell podcast, there's a couple of episodes on the civil rights movement in the States. And Brown, there's an episode specifically on Brown and Board of Education, which is going to change what you think about that case. And there's a great episode called The Lady Vanishes in, I think, season 1. It might be halfway through season 2, which, if you're interested in the subject of equality, is, well, frankly, it should be compulsory listening. It's, again, absolutely fantastic. Can't recommend it highly enough. Revisionist History by Malcolm Gladwell. Thank you so much for listening. Take care.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.